mute.
Good evening and welcome to another episode of Reasonable Doubt, brought to you by Harris County Criminal Lawyers Association. I will be hosting you again tonight. I'm Justin Harris, and usually behind the cameras, but unfortunately y'all got me out in front tonight. But very fortunately for everybody tuning in, we've got a continuation from our episode from 2 weeks ago, from October 12th. If you did not see that episode, you can find it on our Facebook page, facebook.com should be /HCCLA, or just search Facebook HCCLA or Facebook Reasonable Doubt, or on the Houston Media Source YouTube page, should find it there as well. It's an excellent episode where Thomas Overhouse came on and talked to us about some more than shady goings-ons from a trial that he and his trial partner, Jessica Ebbs, who's with us tonight as well, experienced. So those of you who did watch, you know that last time we talked about Clay Harrell and his role in this trial, and Thomas was great enough to share that story all the way up to the verdict of the trial. So we're going to kind of continue on, and maybe Thomas or Jessica can give us a little bit of a recap from last time, and then hear the kind of the part two of this. Thank y'all both for being here tonight.
No, thank you so much for having us.
Thanks for having us.
Yeah.
So on the last episode that we talked about this, I basically kind of explained what our experience going through the trial and ultimately how we came across the discovery of the information that led to this whole thing taking off. And just to kind
this
of
was the other complainant, right, who had gotten shot by the guy who apparently told investigators during y'all's trial that your client didn't shoot him, and that he knows that he didn't, and it's somebody else with a different skin tone that he saw. And the DA tried to pass this off as he says he wasn't shot, and instead it was he was shot. He knows who shot him, or he doesn't know who shot him, but he knows who it was not, and it was not your client.
Yes, and that information had been shared with the prosecution in July. Our trial was in the middle of mid to late September.
Mm-hmm.
So they sat on that information for months before we even started our trial.
All the while, never mind the fact that there's like someone who murdered somebody and shot somebody else still roaming the streets of Galveston. Right?
You know,
that's an
semantics.
Yeah.
Semantics.
We got one guy locked up. Doesn't matter if they did it or not. Yeah. We got everyone's safer with the wrong person locked up. Sorry.
Right.
I also told y'all before we started, and I'll tell the viewers too, I will try to talk less and interrupt this wonderful story less as well. So, but yeah, go ahead.
No, I mean, any direction's helpful. We've been dealing with this for so long, and we've had so much information that it's easy to get into the weeds because there's so much minutia and detail that, you know, from us and our perspective with what we went through, every little single tiny tidbit's important, but you know, it's not always the most efficient way. But yeah, to circle back to what you were saying, we ended the last episode where we discussed that once we'd received that information, we called the other complaining witness as a witness to testify on the trial. Miss Ebbs is actually the one who took him on cross or direct examination, sorry. And since she's here and able to join us, I'd like to give her some thoughts about her experience with directing that witness and how that all played out, if that's good with you, Jess.
Yeah, of course.
And Jessica, were you the one that went over to the jail and met with him?
Yes. Yeah. So that
you're
was
the one
me.
that uncovered what really happened.
Mm-hmm.
So,
and that's kind of how I was going to start, is the feelings. I mean, they're kind of coming back to me. There was one feeling going to the jail and hearing this guy who, by the way, our client was also charged with assaulting him for the shooting of him. So he's charged with his case and then the case we're on trial with. So hearing him, I mean, very easily tell me that, yeah, your guy wasn't the shooter. I told the DA's office that. I mean, I was almost like, come again. This can't be really what you're telling me. Right. And so I'm like, are you willing to tell this in trial? And he was a little bit reluctant. But after kind of telling him what had gone on, he was really adamant about wanting to do it. So it was a pretty quick conversation.
I'm doing it again. I'm interrupting, but
It's
No.
I just
okay.
have to say, like, as someone who's gone over to the jail and met with like people who are, not totally surprised to see us, right? There are clients like, oh, it's you. Okay, yeah, cool. What's up?
Mm-hmm.
This had to be kind of a different experience for you, right? You're going over, you've gotten permission from his lawyer to talk to him directly because he's in there for something else, right? But
Right,
he's
right.
also a complainant or a victim in this
Mm-hmm.
aggravated assault with a deadly weapon. So then this guy comes out, right? Like in the green jumpsuit that they wear in Galveston. And he's like, yes, ma'am, who are
Who
you?
are you?
Like,
Uh-huh.
yeah. And then you're like, okay, so here's who I am. I represent the guy who's accused of shooting you, and I want to have a conversation. I mean, that right? That's kind of
Right,
how I would
right,
imagine
right.
this starts off. And then he's like, I don't know. And you're like, well, let me tell you what they've been doing with this BS statement that they
Mm-hmm.
supposedly had. And then he probably sitting in there and he's like a lot of our clients, they get worked up about injustice, especially when they feel like they're subject of it and they get this little chance to do something. And I've seen lots of times people are willing to help, not to like snitch, but to like either break the boredom of the everyday monotony over in the jail, or like, hey, there's something in the system that is going to
Right.
work right. Like I
I
can be
would
part of
hope,
that.
like, kind of, I would hope if somebody else is in this position, they would do the same for me, kind of thing. And that's
Yeah.
exactly what happened. Once I told him how things were going and how he was kind of being portrayed, he was all on board. He wanted to help as much as he could, knowing that I'm like, you're not going to really get anything from this. There's
Right.
nothing I can offer you. But the way I started the conversation, I was grateful I did, because, there's a lot of, oh crap, how do I approach this? I've seen a lot of people in jail, but this isn't my client, and he could tell me just to
Mm-hmm.
screw off. If he does, he does, but you want it to go a certain way, right?
Sure.
So I went in and I apologized for him being shot.
Okay,
And
that's a good approach.
I'm sorry you were shot. And by the way, did you know that the state is telling us and saying that you said you weren't shot? I mean, is it true? And he's like, what? Of course that's not true. I was shot. And he said this, it's on the record. He said, I was shot in the ass. And he said that
Okay.
in
He said that
trial.
on the
He
stand.
said in front of the jury, which got some laughs. But and that kind of broke the ice a little bit. And it also kind of turned the table, like, look, this is how you're being portrayed. So all of that goes down. And meanwhile, Thomas is over in court because we're supposed to be there. I mean, it's got to be past 8 at this point, right, Thomas, when I'm over there? So we
Right.
were supposed to be there, first thing. And so Judge
Oh,
Robinson, the
and
whole
how
court,
pregnant were you? How pregnant were you when you were doing all this?
I was not pregnant then.
Oh, wait. Okay. I'm off on my
Yeah.
time. Okay. All right. I was just adding that
It
to
would
the
have been a
drama,
better
but
story, right? I know. I
yeah.
wish I was. But Thomas is holding the fort down over there. The judge is like, where's Jessica? Why isn't the whole team here? He's
Well,
holding
and
it
remember,
down.
Rondell had gotten arrested.
Oh yeah. So we had to deal with that whole mess. I'm sure
That is
So,
so
you've
crazy.
that
That story
recap.
too. I've told like 3 people that story. I'm like, what would you think of this? They're like, wait, he was a witness in the case? Yeah, he testified already. Then he went out and arrested the guy. I mean, that's crazy.
and
And
had
then
a
to
DA ride along with him.
yeah,
Right.
yeah,
I even forgot that little aspect of it, but yeah.
And then by the end of the trial, no probable cause is found. And then that
Right.
same DA goes and indicts it later. Anyway, so once we get back to court, we've got this piece of information, and you just want to like sing it from the mountaintop, right? But I can't
Sure.
tell anybody at that point. But to kind of fast forward a little bit, when we've got him on the stand, I mean, I was talking to Thomas about this a couple weeks ago, actually, and this is probably one of the most terrifying things I've ever done in my life, because I knew
Oh,
what he had told me in that jail cell. I knew or in the holding room, whatever, the attorney booth, and I knew what he was supposed to say. But him saying it on the stand is a different thing. I mean, we all know, being trial attorneys, that you can prep a witness, you can talk to a witness, and 5 seconds later they might say something else.
fall apart.
And asking this guy point blank, did my client shoot you? I mean, we were told in the beginning of this trial that he was basically a Looney Tune, right? I mean,
Right.
he ha ha ha, he says he wasn't shot. And I didn't believe that. Thomas didn't believe that. But when you've got your client's life in your hands, I mean, I'm asking him a question, and if it goes a different way, then I just sealed his
You
fate.
just exactly.
Yeah, yeah. And
It's a
so
big basket and you're putting a lot of eggs in there.
So, I mean, I just took a deep breath and I looked at him like, come on, don't steer me wrong, buddy.
Right.
And I asked it and he said, yeah, no, your guy wasn't the shooter. And I mean, it was the scariest and then also kind of the most gratifying moment, because it
What was
just
the
the
courtroom
whole.
like? What's the
That's what
court?
I was
Because
about to say.
yeah, I'm
It's
sorry.
all it's okay. It's okay. I mean, Thomas, you might be able to answer that better because being in the one question, I mean, for me, it felt like it was
Yeah.
quiet. It was like it was all eyes were on us, especially
Mhm.
in that moment.
So,
I mean,
no, you could hear a pin drop. Of course, I'm trying to look at the jury to see how they're receiving it. But, I'm also looking at Clay. It's like, we gotcha. We,
Yeah.
want to see how he
Mhm.
responds. And he's just sitting there. He's taking notes. He's scribbling stuff down. But the jury, man, they were eating that up. It was,
Mhm.
you
Remember their
normally you get
heads
some.
going, just
Whoa. That's the
everywhere,
Perry Mason
everywhere.
moment that you like don't get. Everybody, all the jurors
Right.
think you're gonna have that moment in a trial, right? Like in TV. You rarely get that. And when you do, you're like, did it make an impact? Like I think, you're like, I hope.
Right.
Like, did you see what they did? Because I know what you're talking about, Jessica. You're in that moment and
Yeah.
everybody's looking at you and you're like, I gotta act like this is no big deal. I gotta just like keep it going, but also like pause for effect. Like, they getting it?
Right,
Okay,
right.
now I keep going.
But this
And I'm
was
bad at
such
that.
a
I'll ask the same question, like, say that one more time. Like, I
uh-huh.
don't know if they heard you a third time. Like,
Right.
ask and
But
answer.
this is such a big moment that
Yeah.
you ask it and you look at the jury and you're like, you could see them. They're all just on the edge of their chairs. Like, they heard it, but you're like, just in case I got to ask it a different way. Like
Yeah, yeah.
just, I got to hone in on this.
It was like they were watching a tennis match. It'd be like this
Mhm.
and the back, and then and
Mhm.
so we could tell that it was resonating really well. He, for all his credit, he came across very charming. I mean,
Mhm.
when she asked him, she goes, "Now, of course you were shot." He goes, "Yeah, I was shot in my ass," and everybody starts laughing. And so it's at that moment we're like, "All right, we got the jury. They're
Mhm.
with us."
Yeah.
And so,
And we
but
walked
so
him through too. We walked him through the fact that, and you met with an investigator from the state of Texas on a previous occasion. Yeah, I did. And did you tell them this? Yes. Well, did you tell them you weren't shot? And that's whenever they said what Thomas just mentioned, and he gets the jury kind of even more on his side. So yeah, he was a very credible witness, despite what, Clay wanted, I think everybody to believe that he wasn't a credible witness. I found him quite credible.
and he did the stereotypical prosecutor try to disrupt the credibility kind of stuff. I mean,
Mm-hmm.
it was after a bombshell like that, it was wholly ineffective. It didn't do anything. If anything, it made their case look even worse because remember in the last one we talked about how just the quality of the investigation was garbage.
Yeah.
So that was just the final little straw. So we get a very quick verdict. And
Is that the point when there's a discussion in chambers? Like after that witness, is judge like, all right, take the jury out, counsel, come back here. And then is that when he's like, what's going on? What are we doing here?
it
Or is
was
that earlier?
before
Okay.
when we told him we needed it brought over from the jail.
I
And
see.
he expressed a little bit of frustration because we could have given them advance notice and he would have been there and we wouldn't have wasted some of the jury's time. But like we discussed last time, we did
Strategy.
it strategically because we didn't
Yeah.
want Clay to have any time to kind of fix this up because we knew what had happened in our heart. I mean,
But I think we did
So
go
let's
into chambers
we
again
did.
after that witness. Yeah, we went into the hallway before the witness and had a, off the record. I think it may have been on the record, but it was outside presence. And then we went into chambers after the witness to kind of recap and that, I don't know if you guys went into it, Thomas, the discussion where
Yeah.
we moved for the mistrial, but at the same time didn't really want the mistrial, but we procedurally had to do it. And then the judge was asked Clay point blank if he wanted to proceed, and that was to me the moment in the whole case where it kind of comes down to, for me personally, is when this happens, if you truly made a mistake, if you truly in your heart of hearts said, oh crap, I should have disclosed this, and it's now come out, even knowing that this jury is probably going to come back in our favor, if you're asked by the judge, are you going to let this go forward to a jury? Your answer should be no. As a prosecutor, you have a duty to say no. I will. A jury can do anything. We all know that. With the strongest case in the world, they can find him guilty. So the fact that he said, yes, I want to proceed to a jury, that's the point for me where I'm like, that's unacceptable.
Did you get a sense, and you don't have to say it, but did you get a sense that the judge was kind of also testing Clay's moral compass at that point? Or was it just more of like a rudiment, like a regular, hey, you still want to go, or any emotions?
I think Judge Robinson was just as surprised as everybody in that moment. So I think he was in that moment truly asking him, are you really going to let this go to a jury? Do you? And he asked, you want to get somebody higher up here to make that decision? Because Clay was real quick. He said yes.
It was kind of like, are you fucking kidding me? Kind of moment. Like, he didn't say those things. Of course, we were on the record, but that was his tone. That was his part. He's like, are you serious right now?
You could also view it as like a judge was giving him an opportunity to make this right,
Yeah.
I mean, you really could. And I think it was a combination of all of these things, because it was a very emotional situation, for lack of a better way to say it, because there was so much going on. And I mean, it was kind of like hey, here's your olive branch, do you want your way out? And he said, nope.
Yeah. So how's your client taking all this?
I think he's in shock. I think he's in shock. I mean, we've told him what's happening. Remember, he just spent the night in jail as well. And so he's processing it at several different times. He leans over and he's asking me what's happening. Like, what is this? And we're like, look, let's just roll with it. This is good for us. This is our best strategy we can put forward.
He's kind of shell-shocked is the best way, Yeah. So, I mean, he was happy that, he's like, finally, or, like things are going in the direction they should, or my way. But then, we take one step back, always with this trial. But I would say he was happy, but he was also, he was just very abused by the system, I think. So he was ready for anything.
Well, yeah, I've had clients in the past who were kind of given raw deals based on bias and things, and we've been able to go back and like undo things through motions for new trial and appeals in those situations. But one recurring theme is like just this feeling of being kind of robbed of a sense of dignity. When I had to go tell a client who was first generation American, his family was from Jamaica, and his parents brought their kids here, and they put two of the kids were doctors, and one's has a PhD in mechanical engineering, is like a professor. Like, the parents wanted their kids to do better than they ever could imagined, and they did. And this man is a doctor, and he came every day of trial, dressed in a perfect suit. And he explained, I have these nice suits, but I never get to wear them. It's always in scrubs. And when we found out that the jury, after they convicted him, that they did it based on some racial bias issues, and I had to go tell him that, he was upset. He was like crying. He was like, really? That's what this came down to? Do they know I'm a doctor? I'm like, that's it. Like, at the end of the day, they just couldn't see past my skin color.
Jeez.
So we fixed that, but it's kind of hard, right, on somebody to sit there and be like, man, this guy's been accusing me of killing somebody, and he knew I didn't do it, but he's been sitting here for all week telling this jury I'm a murderer, and he knew I wasn't. Yeah. Like, I mean, I think the shell shock, the emotional trauma of any trial, the exhaustion of it, and then you add that into it, it's got a really kind of sting, for lack of a better word.
It did, and we tried our best to kind of temper some expectations, because you just don't know what that jury's going to do. So we're telling him, look, this is a huge deal. There's some problems now for the state. We've really put forth a very good issue for the jury, but we still don't know how this is going to come out. And
Right.
when we got that really quick verdict, I think that shell shock compounded on itself. I mean, he was standing there just knowing. He goes, I don't know what's going to happen. And when it came out not guilty, he kind of had an even more shell shocked, and he's like, what just happened? And we're like, that's
Right.
it, we're done. And he started crying.
Mhm.
And that's maybe that, however many minutes, seconds it took for them to, bring the jury in, read the verdict and all that. I mean, that is the most impactful moment that I've ever had waiting for a jury as a prosecutor and a defense attorney. I mean, I don't know. I've never experienced anything like that. And so
Mhm.
Pretty powerful.
I can't even imagine what it was like for him. We go home at the end of this. If it doesn't go his way, he doesn't. Even if there's a wrong, even if it's something that can be corrected after with a post conviction writ, he's still got to sit there while all that's getting sorted out. So,
Well, and you know what a lot of people don't know is even if they're not on bond and they're found not guilty, they have to go back, put the green jumpsuit back on, go back over to the jail, and then get processed back out of the jail. All the while they're in jail as a totally innocent person.
innocent.
They have been found
Yeah.
not guilty. So yeah, even when you're found not guilty, you got to go back to jail before you can get out of jail. It's something that I think that the sheriff's offices around the state could fix pretty easily, but
Mhm.
right now where there's not a will, there's not a way. But
Yeah.
so we got the trial. The verdict was quick, not guilty. That's good. Juries can follow like things that they should. But then y'all are sitting there going, this isn't over.
Yeah.
Right.
Oh no.
No,
So what
I mean,
happens is the next day, do y'all take a day off from this murder trial, or do y'all just hit the ground running next morning?
No.
What's next?
we were so angry, we hit it running. We spent the better part of the rest of that afternoon, evening, nighttime, and started working on our criminal complaint. We contacted the local Texas Ranger, said, hey, this is something that we're working on. We're going to send it your way. He
But
said,
Thomas, not to interrupt you here, but did you go into how you fought them for the
yeah,
subpoena?
we did that.
You did?
Yeah,
Okay.
we did that last time. We tried to get those records subpoenaed, and
Oh yeah.
the public, it's no longer county legal, but whatever his capacity is, he defends the DA's office in outside matters. So fought that complaint or the subpoena for the Odyssey notes, which is where the investigator put documentation of his interaction. We said we weren't going to let it go. We show up on Monday. They tried to dismiss the pending charge against Mr. Kendrick Gordon, who was the surviving complaining witness. And what they tried to sell it to us was, look, no harm, no foul. We're dismissing this case, no big deal. Why don't y'all just walk away and let it go? And we said no. They still wouldn't give us the notes. So
Wait, tell the viewers what's significant about if they had just so he was charged with two things: murder and aggravated assault with a deadly weapon. They just tried the murder and he was found not guilty. So Correct. They still had that pending aggravated assault. What's significant about the DA trying to offering or trying to dismiss that or moving to dismiss that? And then what'd you do? How'd you respond to that to the court?
So when somebody's acquitted, they're entitled to a free automatic expunction, which means that every bit of the record would be dismissed. Now, what complicated that is because the aggravated assault charge out of the same transaction. So that kind of inhibits the expunction process a little bit. But what what I think the DA strategy was with that was, if we dismiss the aggravated assault, it's either going to, one, be we're going to make them happy. There are no more pending charges. Everything's fine. No harm, no foul. But two, by dismissing that, that could have stood in our way as a roadblock to get access to those notes, because there's now no longer a pending case and a pending issue.
Okay.
So we filed the
So,
subpoena in that active case. And so
yeah,
If
they
that active
only,
case goes away, there's no case to issue a subpoena.
it's moot now.
Right.
It's not, it's a non-issue. And they
we
only
lose
made that
standing.
decision at the point where we pushed them to that point. You know, you'd
Mhm.
think after that testimony, you just signed the dismissal, right? I mean, but that's not what it took. It took us filing, fighting, trying to set a hearing because it was our only avenue, we thought in that moment. And then also being met the entire time with this pressure, like, what you guys were both prosecutors, you know how this goes. Like, why are y'all doing
Right.
this? This is ridiculous. Like, y'all won. Why y'all are just whining? And so, I mean,
Wow.
for almost a year being told that, you know, not by the defense side, but you know, by the
Sure.
state. Not all of them, not all prosecutors, but a lot of them telling us that, and especially on this issue, I would say.
And so we consulted with our client. We got his permission. When we found out that dismissal had been filed, it hadn't been signed by the judge, and we go in there and we asked the judge not to sign it, and we explained why we're asking him to do that. We said that we want the records. We want to know exactly what happened. This is not the end of our actions on this. We're exploring potential bar grievance and potential other avenues that may present itself. We already had an idea of what we were thinking, but we didn't want to telegraph any of that. So
Right.
the judge understood that. He agreed not to sign it. I think.
I mean, at that point, Judge Robinson's like, nothing crazier has happened in this case than defense saying,
Mhm.
no, don't dismiss my
That's
client's ag assault, right? Like, I've done that
it's
before
one of
too. I've
those
had to
weird
tell a
things.
judge, here's why I don't want you to dismiss the case yet. Just hold on to that motion. Not for
Right.
these reasons. This is righteous and great, but yeah, that's a wild roller coaster for the judge to just sit there and be like, I just work here. Sure, you guys want me to sign it? That's fine. I won't.
But he really, I think, and that was kind of the last decision he made in the case. And I think this was really wise of him because, you know, he had denied our motion for mistrial that we had made after a lot of this started coming out. So after he says, I'm not going to sign this, I agree that if you guys want to pursue this, do what you got to do, but it's my time to bow out because,
Okay.
you know, I made an adverse ruling against you guys. And so to make these decisions going forward, I think it needs to be somebody else. I
Makes
agree
sense.
with that. I mean, we love Judge Robinson. He's a fair judge, but it makes sense for him to do that. And so that kind of, and I don't want to interrupt you, Thomas, but that kind of created a
No.
little bit of a delay for us because then we had to wait for the administrative judge to assign us out to another judge, essentially.
Well, and that's kind of where I wanted to kind of fast forward to. We discussed last time we filed the complaint, sent it to the Rangers. At the almost simultaneously, the district attorney's office, the elected, the first assistant, I believe we also sent it to the felony trial bureau chief, Kayla Allen. We sent them an exact copy of what we had sent to the Rangers.
And Jack Rody, yeah. Did you say that?
The elected. Yeah, I'm sorry,
Oh,
Jack
okay.
Rody, the elected.
You said-
And then we had no action for months. Nothing happened.
They didn't respond to the email like received, thanks.
They didn't call us. They didn't ask Mark, hey, tell us what happened. We want to look into this. We take this serious. Nothing. They
And Mark is
buried
Mark
their
Diaz, both of y'all.
yes,
Boss,
boss,
owner of the firm.
Yep. Who deserves all the credit for us and who we are. But
Oh, he signed your paychecks. That's right. Yeah, Mark gets all the credit.
I mean, if there's anybody in this whole picture who deserved the modicum of respect that was not ever given, it's Mark.
Yeah.
He's not somebody that pulls the fire drill for no reason. He's not somebody who would have let us kick up all this dirt for no reason.
Right.
And they have known Mark much longer than they've known either of us. And for them to not even extend a courtesy, hey, we get this, we take these things seriously, we're going to look into it, tell us what happened.
We take these things seriously when they come from somebody like Mark, you know, because they don't come from people like Mark, because they're rare. I mean, it is
Right.
it can be rare for something this extravagant to happen, right? But especially when it comes from a good, solid attorney that doesn't kick up the dirt like this just for fun. He does it
Right.
when it's legit. And it was insulting, honestly, the fact that we didn't hear anything for so long. And so
Well,
it's like
and
we were fighting ourselves every day, just trying to prove that this is something.
and an important little note there too is they haven't recused themselves yet. So it's not like they
Right.
were able to even hide behind something saying like, well, we didn't talk because we decided out of impartiality or,
We're hands off the
optics
whole
to,
thing.
yeah, nothing, no activity. So eventually, the new administrative judge took over. We approached him. He signed the order to appoint a pro tem. It was an individual out of Fort Bend. Uh, and
What
they
is
took
that? What
over.
is a pro tem? What does that mean?
Oh, sorry. So that's
That's okay.
basically a prosecutor who would stand in the shoes of when a DA has a conflict, whether it's one of their employees that's been accused of a crime or they've been accused of some kind of impropriety, they step aside to bow out because, as everybody really knows, it's not always practiced this way, but you can't police the police, right? Somebody
Sure.
else has to come in and step in. And so pro tem is that person. He's somebody who's going to act in the same capacity and role as a prosecutor, but it's just not somebody who's related or affiliated with that regional or that district attorney's office.
Was it the someone from the Fort Bend County DA's office or a
Yes,
defense attorney from okay. All right.
it
So
was.
it's
It
somebody
was.
who's already a prosecutor in District County.
Yes, it was actually the public integrity prosecutor
Oh,
from that.
okay. Okay. All
And
right.
so
And I think
they
it's
began.
important to note this kind of, sorry, Thomas, to interrupt you, that it took a lot to get a prosecutor to take this case. And I can't say why. I can't, I wasn't involved in that process, but I can imagine why. Because the way that it works is, I don't know if they email, they call, but essentially, the word goes out to your surrounding counties. Here's the situation, who can handle it, wants to handle it. And I mean,
Really?
generally you get bites, and this one wasn't getting a bunch of bites. And like I said, I don't know this to be the truth, but I can imagine it's because it's a prosecutor that we were
Sure.
going after. And you don't want to be the prosecutor that goes after the prosecutor. I mean, that's a tough
Right.
line to cross. So we kind of sat stagnant for even longer than we did before. So there were all of these hurdles every, turn we were taking, there was a hurdle,
That's the
so
word. There's a roadblock.
yeah.
But eventually we get there. And so he and his investigator came and kicked off the process. Not entirely sure where he started, but I want to say it was with us. He came and he kind of got overview of what happened, and then told us he'd be back. And then later on, I think he came and or asked for our recorded statements. And I think we later learned after we did a Public Information Act request that he conducted several other interviews that exact same day. So during that interview with him, after our interviews, I think we had another appointment with him. Correct me if I'm wrong, Jessica, but that's where he kind of came back and said, look, I believe there's something here.
Yes.
Mm-hmm. I think
we got a very different feel from it than we were beat down, I would say, in the beginning, but still kind of hopeful. And then after that next meeting, we felt re-energized.
Good.
He said, and he did what you would do with any client. He says, look, I think we have enough for an indictment. I feel confident in our ability to secure that. Trial, that's a different issue. Beyond a reasonable doubt, it's a much different standard. Based on my conversations, which he wasn't revealing to us at the time, for good reason, because he wants to protect our integrity if we ever had to go to trial. It doesn't,
Sure.
doesn't want us to get impeached with those kind of things. But he said, we're going to move forward. I'm going to take this seriously. And here's my scheduled or intended date to present to grand jury. And we said, okay, we're here. Let us know how we can help. Let us know what we can do. And thank you so much for giving us the attention that we think this deserves. And, ultimately this is our client, but our client, he's not in the position to articulate exactly what went wrong and how it went wrong and what is he's not a lawyer. So he just knows that somebody lied and kept something from us, and so we're the ones that are his voice in this whole process. And so then we just wait for our grand jury date. And
but meanwhile, Thomas, I hate to keep interrupting you.
No,
add to that. Being told, as we all know as lawyers, and this being an open investigation because there's no arrest, it's going to grand jury that decides. Being told very, very, clearly, do not discuss this case with anybody else. You could compromise the open investigation. I mean, it was hard, right? This is really hard not to talk about, especially in that moment when we're finally getting, I don't want to say attention, but the attention the issue deserves, rather.
Yeah.
And so we can't talk about it. And you've got defense attorneys coming at you left and right, and you want to tell them so bad, but you can't, because all the while Clay is still in the court trying cases, and you know what you know, and you can't talk about it. Right. So the reason I interrupted Thomas there is because I think that's important for a later part of the story.
Well, it is important because I think we kind of touched on this a little bit last time, but aside from us not even getting phone calls or being addressed by the actual DA's office itself when this first came up, they left him as the district court chief in that court where he tried several other substantial cases. I think we talked.
You mentioned he was like in a capital murder, like the next week.
Yeah.
We served them with the criminal complaint accusing Clay of what we did on a Friday, I think it was. It was a Thursday or Friday, and he was trying a capital juvenile certification case the next Monday or Tuesday.
On Monday.
Wow. So a capital where the person was a child when they committed the alleged crime. Wow. Just took, like, the biggest stakes case he could.
Yeah.
Man.
Yeah, I mean, that.
So the grand jury date comes. Do y'all testify in front of the grand jury? Do you get a phone call? What happens then?
So the original grand jury date had to get moved because of some conflicts. The special prosecutor. Is this going to be
a Galveston County DA? I'm sorry, a Galveston
grand jury. Yes.
Okay.
We were assured, and based on what we received from our Public Information Act request, it would appear, at least on its face, that he had not presented to this grand jury.
Clay.
Clay. I'm sorry. I think we have a follow-up Public Information Act request coming, but
that was one thing that I asked you last week.
It's kind of funny that when we posed this question, it was like we were the first ones to ever think about it. Who qualified this jury, and has he ever presented in front of them? Because you guys haven't taken him on any sort of hiatus since we've been doing this, so it's reasonable to believe he's been before this grand jury and developed a rapport.
Yeah, those grand jurors could be like, "Wait a second, what's your name again? You're from Fort Bend County, right? Okay." Isn't this about the guy who we see come in here like every other week and present cases to us? And we've trusted his word and found him credible to present indictments to us. So, and if we've rubber stamped, that's right.
Yeah,
we've rubber stamped all the things that he's asked us to, then we can't now say he's not a credible person, because then we're on the hook for it. Yeah.
Right. So that right now it looks like he has it, but there's more digging to do to actually answer that question. One way or the other.
It's still not over. Yeah.
No, it's still not over. But the special prosecutor had a public integrity Fort Bend case. There was an officer involved shooting. Don't know any of the details, but it was a pretty serious case that he's set, locked, and loaded for trial. But the other interesting tidbit was that he disclosed to us that Kevin Petroff, the first assistant, had also reached out to him and said, hey, Mr. Harrell needs more time to put together his grand jury packet. He's got a very demanding trial schedule right now. So that
it's like a self-created problem. Like, hey, my guy he can't respond to this thing because I've got him overloaded with a bunch of work.
Well, and why the first assistant is advocating and assisting in any fashion. Not saying that they helped them make this grand jury
they've stepped aside, right?
Yeah, but why they're asking for more time for this guy who's been accused of what he's been accused of to this? I know. I mean,
Clay should have his own attorney.
No,
his
that's
own attorney
could
say. I mean, that's what I do for my clients. Hey, guys, we need more time to prepare the grand jury packet. Can y'all give me like 2 more weeks? And
yes, bingo.
That's what an advocate does, right?
So Petroff is still
advocating for his employee.
That's kind of the role they took on at that time. Is how it seemed like that was their client.
Right. And so, he reaches out to us, runs this by us, says, but look, this works better for me because I've got this big public integrity trial in Fort Bend. And so we say, okay, no big deal. So that grand jury date gets kicked out to September 19th, I think, of this year. So we're almost at a year after this whole thing happened. More than a year if you want to count the extra several months that he knew about this and never disclosed it to us.
Sure.
But
right.
So we say, okay, we're here, we're available. That day comes along. We knew it was happening. We were in court for our own business there. And we heard from other individuals in the courthouse that Mr. Clayton Harrell was walking into court with a big box, which we can only assume was the grand jury packet. And then we heard he got escorted into the district attorney's office. So behind the closed doors, and they put him up somewhere.
Because so at this point, Thomas, do we know in the story that he has been terminated? I mean, did we get there?
Oh, I believe we touched on it last time, but if you want to recap on that, just to make it a little more clear.
Well, and I forget the exact time frame. Yeah, maybe like what, 2-3 weeks before? Yeah. So 3 weeks before. Well, and it would have been. Was it after they asked for the extension?
It was after they asked for the extension.
because he had all these trials. Yes, and one of them he tried, and then he tries a big case. It ends on a Friday. He gets a guilty. Not a similar issue, but another issue that's just shouldn't happen to prosecutors over and over like they do him happened in that trial. And then the next Monday, I believe is when it happened. He was fired.
Hold on. We forgot something about Clay's termination that happened before the grand jury presentment.
Yeah.
During our little gap while we're waiting from the original date to the new date, we received a phone call from the special prosecutor, the pro tem, and he said, hey, haven't talked to anybody at the DA's office yet. Nothing's out there. I just wanted to run something by you guys. So he called Mark. He said, how would you feel if they just terminated him and then that's enough. You got your pound of flesh. We all walk away. All three of us, I think we had several discussions over the next 24 hours about it. And
hours.
Ultimately, we decided that because they never showed any amount of decency or respect, and even giving us a phone call when this initially happened, This is going back to what we were talking about maybe 20 minutes ago with them burying their heads in the sand and not even addressing this with us on the forefront. We felt, one, they were hiding something. We felt, two, there was something potentially more that we just weren't privy to yet. And three, we felt insulted by the fact that they never even showed this the care and the diligence and the importance that we felt, and that I think everybody else who does this for a living would feel. They didn't do any of that. So we said, no, absolutely not.
For me
And
personally, it came down, and I think, and I don't want to speak for everybody, but I think everybody, feels something similar to this. Yes, it's great. It would have been great to just get Clay out and we would forego the indictment, because we had a lot of cases with him and he was not doing good work in our eyes. But when they didn't acknowledge the issue, when they went almost a year without doing anything, it becomes more than just a Clay issue. It becomes an office issue. And if they're letting this happen here, then they'll let it happen again. So, and like I said, I don't want to speak for everybody, but for me personally, that's where I stood, is that this isn't right. It's not just right on his level, but they've rubber stamped his behavior by letting it go this far.
It's beyond not right. The complaint that y'all worked on, and a Texas Ranger worked on and investigated, then a Fort Bend County assistant district attorney came in and investigated. That's an allegation of a criminal law being broken. Right. And now that I know, I guess I'm imagining that this idea originated in Galveston County DA's office. Like, hey, see if Diaz's crew will be okay with us just firing him.
That's what we think.
So, that's good to know that, like, next time I've got like a gang related shooting, I can just go down there and be like, hey, look, let the case go. My client's going to quit the gang. They're going to let him leave the gang. And then you guys just let the murder go. Okay.
It definitely goes both ways. Yeah. Yes.
Right. Yeah. Of course. So not to make light of this, but I completely understand. You got plenty of reasons to not agree to, like, no. Plus all that might do is just let him, because he moved here from Conal. Who the heck knows what he was doing out there? So now he's like, okay, I'll go try like the North Texas area. Texas is big enough. I can just take my, what kind of show on the road.
It was never going to be enough. And what we also had to consider is that we're lucky. We are so lucky that we figured this out and that there was something to back it up.
Right.
Because just hypothetically, we have no basis for this yet. But what if nobody had ever written any of these notes?
Yeah.
This never would have been discovered. It was too easy for him, because I see that we're kind of running out of time, but we've got his written statement that he goes in at a disgusting amount of deflection and everything else. But had it not been for a note to support what our complaint was that the note, when I say the note, what I mean is the note that the investigator had input into the system, had there not been that to support us, we might not even be anywhere close to where we are today. And we would never have known. And it would have been too easy for him to have come across that information on his own. If, say, he called the complaining witness himself and just never wrote a note, he could have buried that and nobody ever would have known.
But on top of that, Thomas, I think that if it was any other attorneys who had no experience or little experience with this prosecutor, it wouldn't have gone this way, because we had prior dealings with Clay in the past. Thomas and Mark had just tried a very, very high stress
manslaughter
big trial with them where some things went down that were a little bit shady, which is for another day. And we had other issues with Clay in the past, amongst other attorneys who have a lot of cases with him. So without that happening for us specifically, I don't know if we would have viewed the comment that he made to us, hey, this guy said this. I don't know if we would have looked at it with such scrutiny. We would have just taken it and said, a prosecutor can't lie to me, right? They're not supposed to lie to me. You got so much else going on that it wouldn't be crazy to believe what they're saying, right?
Well, and he packaged that the way Thomas presented it to us last week. what didn't let his gut get over that is the way he packaged it and presented it to y'all was supposed to be in a way that's supposed to you dismiss him because he's saying something so crazy. You're like, okay, yeah, that's ludicrous.
Right.
There's not even any point for me to run down that because he's giving you Brady notice, right? Hey, this is something that goes to mitigate or maybe even like impeach something if this guy gets called as a witness. He just says he didn't get shot. Something as crazy as he didn't get shot in the buttocks,
which was on par with everything that the other uncooperative witnesses had kind of alluded to.
Right. Yeah.
To the best of
this is all crazy. Everyone's like, I don't know about a shooting. What's shooting?
But Jessica said something really important too that I want to highlight. Us as defense attorneys, we rely so much on that trust and that faith that the prosecutor is going to do the right thing. And sometimes that's all we got is just the blind faith that they're an officer.
They're not screwing me.
They're not screwing me. They've sworn a duty. They're going to do their best faith. And we rely on that. And who knows? I mean, maybe I think we talked about this last time. If he had called this other guy as a witness, we might not have ever known. Right. It's one of those weird things that is maybe a fundamental flaw in our system as it is, that we as defense attorneys have to put so much faith and reliance on the prosecutors that they're going to do the right thing. Now, that's not to say that the majority of them aren't going to do those kinds of things and that anybody's out there really just trying to like screw everybody over. But the fact that we are in a position to where we have to rely and trust in that. Of course we do our own investigations, but at no point, here we are in a murder trial. We're being told in the middle or after jury selection that they've had this interview and that something at all was disclosed. In that moment, we're relying that he's being truthful and honest because of his sworn duty. And then come to find out, just because we couldn't let it go, he was lying. And we're running out of time, but there are things that if we were to dissect his personal statement and what he wrote, and with conversations with the judge about comments and things that he said that the judge did and said, they're flat out lies. He presented this whole issue of, I was so overworked, I was so stressed. This is Judge Robinson's inability to run an effective court. He put me in this position to where it was more than likely that I was going to miss this information. And then when that didn't work, he blamed a medical scare that his wife had.
Oh, right.
Which I don't want to take away
surgery.
from that. Well, that's where I'm getting. Nobody until we got this. Well, nobody until we got this written statement knew what this surgery was. We were told that his wife had a cancer scare. They had to do an emergency procedure to determine whether or not it was cancer, whether or not she needed emergency surgery and medical intervention. And that's what we had been told the entire time. Come to find out a couple of weeks ago when we get his written statement, it was a combination of that and an elective cosmetic surgery procedure.
With the same recovery time.
Two birds, one stone, right?
That's essentially what.
Yes, and that's what bothers me the most about it. Is one, he hid the cosmetic surgery aspect of it, right? He's going to the most scary, which everybody would sympathize with. But here's what I also have a problem with, and I think undermines his truthfulness and credibility, is if this was such the degree of an emergency where you had to drop everything and you were so concerned that she had to have an emergency medical procedure, as he states it. I don't know. I've never had plastic surgery, but I don't know a plastic surgeon who can be on call and not ready to say, hey, you're having an emergency procedure. Let's schedule this at the exact same time.
Let's do a nip and tuck at the same time.
The emergency procedure, per his statement, happened on So happened
It was
on
like-
one day.
Yeah,
The
2 days
cosmetic
later.
surgery happened the very next day. And
Wow.
we've run out of time again, and I'm sorry, but there's so much
No,
more
we've got
to
3
that.
minutes. So but the other thing is, I get what you're saying, but if you give him the benefit of the doubt,
Right.
okay, you're stressed out about this procedure your wife's going to have, and maybe you're going to have this silver lining of getting the nip and tuck done the next day, and the recovery time's the same, but you still have the scare of waiting for that biopsy result to come back, and is this going to be life-threatening cancer and all this? I probably would have been like, let's put off the elective surgery if there's a chance you're going to have to go under the knife. But then
Yes.
when you're in that meeting and he tells you something and you're like, hold on a second, I got a lot of distractions going on. Did you just say that the guy we got arrested for the shooting you is not the guy that shot you? Let me hold on a sec. Like, that's the kind of news that whatever you have going on in your life, if you've taken the time to go over to the jail and interview somebody, you're going to go, whoa, that's a big deal. I got to figure that. But instead, he was like, that's a big deal. I got to overcome that to still convict this guy.
In his audio statement, he does one of these like Billy Mays, like, but wait, there's more. If the surgery wasn't enough, I'm also very hard of hearing, so I may not.
He literally
have
says
that.
Yeah. And the interviewer says, "Let me get this straight. So you're now saying you're hard of hearing?" Yes. Okay. All right. You're hard of hearing. But I mean, to add to your point, it's okay. You're hard of hearing. Let's give him that. You don't ask for clarification. I mean, he literally says to this guy, I rely a lot on reading the words coming out of reading people's lips.
Lip reading.
And then watching their expressions. And so I didn't pick up on it. Well, okay, fine. You didn't pick up on it. You didn't ask them when they were in your office. They office with you every day. You didn't follow up. And then on top of that, why didn't you look at the note?
Right.
If you didn't hear it, you can read, can't you? You haven't lost your sight.
Wow.
And I think we've all kind of had a client who does, this is why this happened. And if you don't believe this, then this is why it happened. And if you don't believe that, and then this is why it happened. And so that's what he did. It was,
and they're all our clients because they were not found to be believable or credible, and they were charged with breaking the law.
Yeah.
Right. So there's no scrutiny of these statements from him other than by the investigators. Like, that's what you're going to go with. Like, this is the judge's fault, and you have a hard of hearing. Okay.
This is the judge's fault. If it's not the judge's fault, it's my wife's fault because she had an emergency surgery. And if it's not her fault, it's my
investigator's fault. Yeah.
If it's not his fault, it's the investigator's fault. And if it's not that, then I can't hear.
It's my inner ear. My inner ear's fault. All right, we're getting the wrap sign from Mark Pirtle.
All right.
So look, the good news is I interrupted enough, and Jessica did all the apologizing for that we may get to have another show where we could actually hear what's currently going on, the PIA responses y'all have gotten. So if y'all are willing, let's try to do this again, part 3.
Love to.
Okay. Thank you all very much. On behalf of Harris County Criminal Lawyers Association, Thomas Overhouse, Jessica Ebbs, thank you, Mark Pirtle, Houston Media Source, rocks our world. Thank you all very much. Good night.
Thank you.